Introducing the characters in this video, Pakar Senyum Bank, Abu, Pinkam Bank, Miss Auni, Miss Hidayah, Miss Amani.
Hello, is this Pixel & Co law firm? I am a representative from Pinkam Bank. I would like to have a consultation on certain issues I'm facing with regards to a charged land.
Hello, yes, you are in the right place. We will try our best to resolve those issues, but first, I will need you to explain to me the material facts concerned here. Abu is the owner of a piece of land in Sriwijaya Industrial Park, Sepang, Selangor. He constructed a double-story factory to manufacture trousers. He took a loan from Pinkam Bank Berhad to finance the construction of the factory. As a security for the loan, Abu charged the land to Pinkam Bank. He also bought 20 units of industrial sewing machine under hire purchase from Senyum Bank Berhad. The sewing machines were affixed to the floor of the factory with bolts and nuts. The factory was also equipped with 8 units of custom-made air conditioners.
Abu also turned part of the land of the factory into a hostel to be occupied by his workers. The workers bought 3 units of fully automatic washing machines and placed it in the utilities room for daily use. 2 years later, Abu failed to pay the monthly installments to Pinkam Bank. To recover the outstanding amount, Pinkam Bank decided to foreclose the land and all items attached to the factory. But it was objected by Senyum Bank. Abu claimed that Pinkam Bank has no right to foreclose the items attached to the factory.
The first issue that we have to approach here is whether all items on the land forms part of the land charged to Pinkam Bank. Land, according to paragraph A to D of section 5 of the National Land Code 1965, includes not only soil on earth but also all the subjacent and superjacent things of permanent nature affixed to the earth, whether by nature or by hand of man on things of a physical nature. Here, upon Abu's failure to fulfill his duty as a charger, we ought to determine which item attached to the land forms part of land foreclosable by Pinkam Bank. To dictate this, we must distinguish between chattel and fixture. Fixture are items attached to the land and immovable, thus it shall form part of land. Meanwhile, chattel refers to items even if attached to the land is removable, hence not forming part of land. However, our National Land Code is generally silent on the meaning of fixture and chattel. Thus, per Goh Chong Min against Consolidated Malay Rubber, it was decided that the English law of fixture is applicable and may be referred to in Malaysia. The landmark English case of Holland against Hodgson may be referred to in differentiating between fixture and chattel, whereby the judge had laid down 2 tests as a guidance to resolve this issue. Both tests have been explained in Halsbury Laws of England, with the first test assessing the mode and extent of annexation or degree of annexation, and the second on the object and purpose of annexation, that is, whether it was for the permanent and substantial improvement of the premise, or merely for temporary purpose, or for the more complete enjoyment and use of the chattel itself. For the first test, we must look to what extent an item is affixed or attached to the land. It may be strongly or slightly attached, or it may be resting by its own weight to the land. An item that is strongly attached to the land is likely a fixture, while those which are not a chattel. However, in calculating the degree of annexation, the extent of injury or damage that will be caused to the item upon its removal must be observed. This is because the stronger an item is attached to the land, the more damage or injury will result upon its removal. For instance, a machinery which is affixed with bolts and nuts to the concrete foundation and sunk into the soil will cause great damage when it is removed, granting a prima facie a fixture. Therefore, we can see that it ought to be considered as a fixture and thus forms part of land. Applying the first test of degree of annexation on the facts of the present case, we shall look into each of the items here. Firstly, the 20 units of industrial sewing machine that have been brought by Abu under the hire purchase from Senyum Bank Berhad. As stated in the matter of facts, the sewing machines were affixed to the factory floor with bolts and nuts. Therefore, if we were to disengage the bolts and nuts that are affixing the sewing machine to the floor, it would surely be difficult and cause great damage to the floor and the sewing machine themselves. hence indicating that the sewing machine have a strong physical attachment to the land, and the more damage is done to the items upon its removal, granting it a prima facie fixture forming part of the land. Next, on the 8 units of custom-made air conditioners that have been equipped by Abu in the factory, although there is a probability that they could have not been fixed to the land by anything except its own weight, customized appliances are generally those which are especially made with consideration of the structure and function of the property as to fit it long-lastingly and function effectively. This warrants the assumption that it is likely that this equipment is attached or built into the wall or ceiling of the factory. Considering that, following Shell Company of Federated of Malaya against Commissioner of Federal Capital of Kuala Lumpur, it must have been intended to remain there permanently and would in one way or another be affixed to the land as to become part of the building as long as the factory remained in operation. Thus, in instances where they ought to be removed from the wall or ceiling, it would cause substantial damage to the factory, not only physically but also towards the electrical as well as the air conditioning system of the building. It could also impair the air conditioner itself once dismantled. Therefore, on the degree of annexation, it shows that the air conditioner are also prima facie a fixture as they are strongly attached to the land. With regards to the third item on the other hand, the situation given mentioned that they were fully automatic washing machines bought and placed in the utilities room by Abu's workers for their daily use. In the absence of any indication showing that the washing machine were affixed by nuts and bolts, installed into the wall of the room or tenaciously attached any other way onto the land, these machines were presumably merely plugged into the wall and attached to the land by its own weight. Hence, it would not result in any damage to the washing machines or the premise if they were to be removed, as it could be simply done without the need to detach any fastening or attachment. Consequently, it can be presumed that this is a chattel that do not form part of the land.
According to the first test, I can foreclose the industrial sewing machines as they are now fixtures and forms part of the land, and I cannot take the custom-made air conditioner and washing machines as they are chattels.
Yes, that is correct for now, as the first test is not sufficient to determine if an item is a fixture or chattel. Thus, the second test on the purpose of annexation must also be discussed, as the purpose test would override the degree test.
May you care to enlighten me regarding the second test on purpose of annexation and how all the items are applied?
It will be my pleasure. Now, the question to be asked for the second test is whether the object was intended to be permanent and designed to enhance the value and utility of the land, or is it for the more complete use or enjoyment of the thing itself? As per Blackburn J in Holland and Hodgson, this is significant as to determine if an item is attached to the land for the better enjoyment of the land as a whole, so as to improve its usefulness and value. It strengthens the prima facie that it is a feature. Contrarily, if the item is attached to the land merely for the more complete enjoyment and use of the item as a chattel, it rebuts the prima facie that it is a feature. Amongst the case that we could look into is that the appeal case of Goh Chong Hin and Consolidated Malay Rubber. This case explained how it was held that by applying the English law of fixtures, the two tests laid down in Holland and Hodgson, it was decided that the machinery was a fixture. This was because, based on the degree test, the prima facie is that the machinery were fixtures, and applying the purpose test, the machinery were attached to enhance the value and utility of the land for a rubber estate, hence strengthen the prima facie that the machinery were fixtures. Another similar case, which is Stockfin Company Limited and Chairman Kelantan Council, this case focuses if an item placed on the land to improve and is for the better use and enjoyment of the land, it strengthens the prima facie that the item is a fixture. On the other hand, in Shell Company of Federation of Malaya Limited and Commissioner of Federal Capital of Kuala Lumpur, this case highlights the intention of the item to be permanent and thus forming part of the land, where the underground petrol storage tanks were 2 feet deep below ground and concreted over, indicating that the intention it should remain. Therefore, we were applying the items to the second test. First and foremost, regarding the industrial sewing machines, based on the facts of the present case, as the sewing machines were bolted and nutted to the floor, indicates that it was intended to be permanent. This can be supported by the case of Stockfin Company Limited and Chairman Kelantan Council, as the sewing machines are strongly attached to the land with bolts and nuts. There is attention that it should remain and become part of the land. Moving on, the industrial sewing machines also does enhance the value and utility of the land because the purpose of the factory was to manufacture trousers. Hence, by having the sewing machine, it will help produce trousers more efficiently. Following this, the case of Goh Chong Hin and Consolidated Malay Rubber, the industrial sewing machine attached is to enhance the value of the land for a factory that manufactures trousers in an industrial park. Therefore, the sewing machine fulfills the purpose of annexation. Next would be the air conditioner. In examining the purpose of an annexation test, although the fashion in which it is fixed onto the building implied that the intention to make it permanent, the installation of air conditioner does not improve the utility of the factory whatsoever. Our factory specializes in the manufacturing of trousers. In such business, there is no effect or function that these machines perform aside from providing a conducive and comfortable working environment to the workers. It is therefore purely placed for the enjoyment of the air conditioner itself as a chattel and does not increase the value of the land as a whole. For this, as per Blackburn J in Holland and Hodgson, any presumption that it shall stand as a fixture is rebutted, and this machine should be recognized as a chattel, not passable to the chargee. Lastly, on the washing machines, even if the washing machines were in fact inserted into the building through its walls or permanently fastened onto the floor, the purpose in which these machines serve does not go beyond the enjoyment of them as a chattel. As stated, it is placed on the land for the workers' daily use, making it a domestic item that is not placed for the enhancement or to improve the utility of the land as an apparel manufacturer, but simply to assist these workers' routine and everyday lives. In contrast with the case of Softfin Company Limited and Chairman Klang Town Council, they are placed for the complete and better use of the machine itself, immaterial towards the value and enjoyment of the land. Not to mention, a washing machine does not contribute to the business of producing garments at all. Having assessed both the degree and purpose of annexation test, both outcomes shows that the washing machine should be a chattel, not forming part of the land, thus rechargeable by the workers as the owners.
Thank you, Ms. Hidayah, for explaining thoroughly on the second test. Hence, this indicates that it is more possible for me to claim the sewing machines, right? Are there any circumstances where even if the sewing machines are fixtures, Abu can still claim them?
Well, yes, there are several instances where the general rule in law of fixture is excused. One of them is when there is a written agreement. One means an item may be accepted for the law of fixtures where there is a written submission in a charger and chargee relationship. Where a charge is involved, an item may not be a fixture when the chargee had acknowledged and comments that it is excluded from forming part of the land when the charger fails to fulfill his obligations. This exclusion may be put in the place of certain reasons such as hire purchase agreement or any others. Among the cases that we can refer to is the case of Wiggins Tape Sdn Bhd and Bahagia Trading Sdn Bhd and others. It's regarding the issue in the passing of the title of a printing machine affixed by bolts to the floor on the ground it was purchased under a hire purchase agreement. This case highlights that due to the hire purchase agreement, the defendants cannot acquire what does not belong to them and it cannot be treated as a fixture. It was later decided that due to the fact that the plaintiff was not aware and had not provided any written terms that will favor the hire purchase agreement, the machine is therefore recognized as a fixture and passes to the chargee notwithstanding the retention of a title clause. It is important also to mention that the case of Goh Chong Hin, where in a relationship between charger and chargee, all fixture whether attached before or after the date of charge pass to the chargee unless otherwise provided for in the charge agreement. Now, for your situation, as we have discussed, the sewing machines are fixtures because they satisfy both tests laid down in Holland and Hodgson. However, if the machine falls under any exception, it could be considered as a chattel. Considering the possibility that Abu would want to claim the sewing machine as chattels, he would need to prove that the sewing machine falls under an exception to the general rule of fixtures. The exception available would be if he could prove there is a written agreement for charger and chargee relationship, stating that the chargee would disclaim and exclude certain items from forming part of the land in the event if Abu fails to pay the monthly installment. This is referred to the case of Goh Chong Hin and Consolidated Malay Rubber, where based on the degree test and the purpose test, the prima facie is that the sewing machines are fixtures. Hence, in a relationship between charger and chargee, all fixture would be passed to the chargee, which is you, Pinkam Bank, unless otherwise provided for in the charge agreement. However, in the facts of the case, there is no written agreement that you, Pinkam Bank, would disclaim and exclude the sewing machines in the event where Abu failed to pay the monthly installments. Hence, this exception cannot be applied.
Is this matter could also be related to the hire purchase from Senyum Bank for the sewing machines?
In fact, yes, it does, because the 20 units of industrial sewing machines bought by Abu was under hire purchase from Senyum Bank. It could be possible that Senyum Bank would argue that the sewing machines could not belong to you, Pinkam Bank, and shall not be treated as fixtures because of the hire purchase agreement. However, in accordance with Wigan's Tip Senior Berhad and Bahagia Trading Senior Berhad and others, in a charger and chargee relationship, as Abu did not provide any terms that would favour the hire purchase from Senyum Bank for the sewing machine in a written agreement with you, Pinkam Bank, following that you also would be unable to acknowledge and comment that the sewing machines are chattels if Abu fails to pay the monthly installments, as there was no written agreement regarding the exclusion of the machines from being part of the land. Therefore, the sewing machines are still recognized as fixtures and passed to you, notwithstanding the hire purchase agreement.
I understood very well. Thank you, Miss Auni and Miss Hidayah, for your legal advice. Hello, Mr. Abu. Please have a seat. You may explain the facts to me, and I will try my best to assist you regarding any issues from my legal standpoint. Bakar, the owner of the land adjacent to Abu's land, excavated part of his land to build a cafeteria for factory workers. As a result, part of Abu's land collapsed onto Bakar's land, damaging Abu's stores.
Ms. Amani, based on the facts I addressed earlier, I need your advice as to whether I can take legal action against Bakar for the damages caused to my stores. Are there any conditions that need to be proven?
To start off, Section 44 Clause 1B of the NLC provides that the proprietor has the right to the support of land of any adjacent land if it is in its natural state. And yes, Mr. Abu, there are conditions that must be satisfied to see whether you have a right to support. The first condition is the land at the lower level must support the land above it. In this case, Bakar's land at the lower level supports your land that is situated at the higher level. The second condition is the land must be adjoining with each other. However, the ownership must be separate. In this case, you are the owner of the land in Srijaya Industrial Park and Bakar is the owner of the land adjacent to your land. Evidently, it shows that there are two separate ownerships between you and Bakar, despite the land being adjoined with each other. The next condition is the land must be in its natural state in order to be entitled to a right of support from its adjoining land. Presumably, your land is in its natural state as it is not stated that there is any development, excavations or burden by buildings on the land in the past before you construct the double-story factory. Last but not least, no adjoining support is to be given beyond what is on the land where the owner cannot expect additional support from the adjacent land if his land is proven to be in its vacant state. Here, in your situation, your land doesn't need additional support from Bakar's land because your land is not in a weakened state as it is unburdened by buildings or unweakened by excavations before the factory is built on the land. There is no indication stated that your land is weak in the first place, which needs additional support. All in all, your land meets the requirements to the right of support.
That's good to hear, Ms. Amani. Is the type of support important in order for me to claim?
Absolutely, Mr. Abu. There are two types of support that one may have right to claim from the adjoining land. The first type of support is cross of support for adjacent land or buildings, and the second type is support for adjacent slope land. In the case of Madam Chah Siam and Chop Choi Kong Kong Si, it was held that the land in its natural state is only entitled to such a degree of support as it would have required by reason of its weakened state. Furthermore, in Guan Sun Tin Mining and Ampang Estate Limited, it was held that the appellants were not liable as the land had already been excavated previously. The nature of the right of support is negative, in that it doesn't give a corresponding positive right to support from the adjoining property, but it merely gives a right to take action if existing natural support from the adjoining land is lost or interfered with. By looking at your land, the relevant type of support that gives the right to claim from the adjoining land is the support for adjacent slope line. This is because Bakar excavated part of the land to build a cafeteria for the factory workers, which resulted in the collapse of your land onto Bakar's land that caused damage to your stores. Here, it shows that there is a slope as your land collapsed onto Bakar's land. Thus, your land has the right of support from Bakar's land. Apparently, the nature of support is positive, which gives a corresponding positive right to support from the adjoining land. It can be seen that there is a withdrawal of support and interference by Bakar to your land. Considering all the facts discussed, Mr. Abu, you may take legal action against Bakar because of the excavation works done by him, which resulted in the collapse of your land onto Bakar's land that caused damage to your stores.
Well, I'm so pleased to hear that. Thank you, Ms. Amani, for your legal advices.
Ergo, Abu may take legal actions against Bakar to recover the losses suffered.
Meanwhile, for the issue between Abu and Pinkam Bank, the latter shall have possession of the land, which includes the sewing machine. However, the chattels here, which are washing machines and air conditioner, are under the proprietary of the workers and Abu respectively as the rightful owner of such items.